Hello everyone, and welcome back to our AS and A-Level Law revision series for Syllabus 9084. Today, we are diving deep into one of the most common and often most tricky areas of Paper 4, the law of torts. Specifically, we're focusing on the concept of nuisance. Whether it's a neighbor's loud music, a factory's unpleasant fumes, or a tree hanging over a fence, nuisance is all about the balance between a person's right to use their land and their neighbor's right to enjoy theirs. Instead of just looking at the theory, we're going to tackle this topic through a scenario-based revision. We'll break down a typical exam problem, identify the key legal principles like locality and duration, and look at those all-important case laws like Sturges v. Bridgman and Miller v. Jackson. By the end of this video, you'll know exactly how to structure a high-level response to any nuisance question that comes your way on exam day. Now, let's look at a practical example. This is a classic 25-mark scenario typical of the 9084 Paper 4 exam. I want you to read along with me and try to spot the legal red flags as we go. The facts. We have Andy, who owns a house directly opposite a company called Super Screams. For a long time, there was no conflict because the factory only operated during the day while Andy was away at work. However, things have changed. Due to a recent expansion, the factory is now working 24/7. Andy is now facing a triple threat of interference. 1. Constant industrial noise from the production line. 2. Bright factory lights beaming directly into his home. 3. Heavy lorries coming and going throughout the night. As a result, Andy is losing sleep. But there's a second layer to this problem. Andy's 15-year-old daughter, Becky, can no longer get a mobile phone signal because a new factory extension is physically blocking it from her bedroom window. The task. Our job is to advise whether Andy and Becky can make successful claims in private nuisance. Pay close attention to those specific details. We have a property owner, a family member, a change in the timing of the noise, and a very specific issue with a mobile signal. In our next slide, I'm going to show you the 5-step roadmap we will use to break this messy story down into a high-scoring legal answer. Now, how do we turn all these facts into a high-scoring exam answer? To do that, we use the IRAC method. This is the professional structure used by law students and lawyers alike to ensure every argument is logical and complete. Our 5-step roadmap is built directly on this IRAC framework. Issue. First, we identify the claim and the parties involved. We ask, what is the legal problem here? As we discussed, we will be addressing the claims for Andy and Becky separately to keep our issue phase clear. Rule. Next, we state the applicable law and key principles. This is where you provide your definitions of indirect and unlawful interference and establish that there must be some form of damage or loss of enjoyment. Application analysis. This is the most critical part of your essay. We take those rules and apply them to the specific facts of our scenario, analyzing factors like locality and duration to see if the factory's expansion crosses the legal line. Conclusion. Finally, we look at defenses and reach a clear conclusion. We provide our final legal advice on whether the claim will succeed and what remedies the court might grant. By using IRAC, you guarantee that you aren't just telling a story, but are actually performing a rigorous legal analysis. Let's start with our first issue. Before we even look at the noise or the lights, we have to clear a major legal hurdle: standing. In tort law, this is the gatekeeper question. Does this person even have the right to be in court? The defendant, the occupier. First, we must identify the correct person to sue. Under the principle in Tetley v. Chitty, the defendant must be the occupier, the person with control over the land, or the one who authorized the nuisance. In our case, that's clearly Super Screams. The claimant, proprietary interest. This is where our scenario gets complicated. The landmark ruling in Hunter v. Canary Wharf established that a claimant must have a proprietary interest in the land to sue for private nuisance. Generally, this means being an owner or a tenant with a legal right to possession. As we look at our two claimants, this principle raises two massive issues that you must address in your exam. 1. For Andy, we know he owns the house opposite the factory, but does his status as an owner automatically satisfy the proprietary interest test for every type of interference, such as his loss of sleep? 2. For Becky, here is the examiner's favorite trap. Becky is a 15-year-old daughter living in her father's home. Does the law recognize a child or family member as having a legal interest in the land, or is she merely a licensee? If Becky cannot prove she has standing, her claim for the blocked mobile signal might be legally dead on arrival. Keep these questions in mind as we move forward. The answers will depend on how strictly the court applies the Hunter rule. Once we've established who can sue, we have to look at the nature of the harm itself. Private nuisance requires an indirect interference. Unlike trespass, which is a direct physical invasion, nuisance involves things that travel from the defendant's land to the claimant's. Non-physical interference. The law recognizes a wide range of things that interfere with a person's quiet enjoyment of their land. Think of noise, smoke, smells, and even vibrations. The landmark case of St. Helens Smelting v. Tipping is crucial here for distinguishing between personal discomfort and actual damage. Physical damage. The law also covers indirect actions that cause physical harm to the land itself, like the chemical contamination seen in Cambridge Water v. ECL. The prima facie case, as seen in Halsey v. Esso Petroleum. Once we prove that such an interference exists and is unreasonable, we have what is called a prima facie case of nuisance. Now, let's bring this back to our scenario and raise some critical questions. For Andy, he is facing noise, lights, and lorries. These are classic examples of indirect interference with comfort. But does the law treat light pollution the same way it treats noise pollution? For Becky, her issue is the physical blocking of a mobile signal by a factory extension. This raises a major legal question. Does the law of nuisance protect your right to receive a digital signal? Or is a building simply doing what a building does by standing there? We have established what can count as an interference. Now we must move to the most important part of the rule phase. What makes an interference unlawful? Let's look at the factors the court uses to decide if a neighbor has gone too far. We have identified the interferences: noise, light, and a blocked signal. But are they unlawful? To answer that, the court must decide if Supascreens' activity is unreasonable. The law doesn't expect total silence between neighbors. It follows a rule of give and take. To find the balance, the courts look at several key factors. Locality, as seen in Canary v. Thompson, the character of the neighborhood matters. Is this a quiet residential street or an industrial zone? Duration. Under the principle in Spicer v. Smee, we look at how often and at what time the interference happens. A noise at 2 p.m. is very different from a noise at 2 a.m. Sensitivity. Following the Network Rail case, we ask, is the claimant being abnormally sensitive? If the harm only happens because Andy or Becky have an unusually delicate need for quiet, the claim might fail. Human rights. Recently, courts also consider Article 8 of the Human Rights Act, which protects the right to respect for one's private and family life and home. As we look back at Andy and Becky, this slide raises our most important analytical questions. First, the locality issue. The factory was there first, but it only worked during the day. Does the fact that they expanded into all-night shifts change the nature of the locality? Second, the duration. Andy is losing sleep. In the eyes of the law, does the all-night element automatically make the factory's expansion unreasonable? And finally, for Becky, is the blocking of a phone signal an unreasonable interference with her home life under Article 8? Or is she being extra sensitive about a digital luxury? Establishing the rules is one thing, applying them is another. Let's move into the analysis phase of our IRAC and see how these factors play out in court. We've looked at who can sue and what counts as an interference, but there is one final piece to the puzzle: damage. In the eyes of the law, a nuisance is only actionable if the claimant has actually suffered a recognized loss. Generally, this falls into two categories. 1. Physical damage. This is where the nuisance causes actual harm to the property, like chemicals killing Andy's garden plants or vibrations cracking his walls. 2. Interference with comfort. This is more common in exam scenarios. It's the loss of amenity, such as being unable to sleep or enjoy your home because of noise or lights. However, there is a catch. The law follows the de minimis rule, meaning it won't get involved in tiny, trivial annoyances. The damage must be significant. Furthermore, the harm must be a foreseeable consequence of the defendant's actions. Now, let's bring this back to our specific issues. For Andy, his loss of sleep is a clear interference with his comfort. But is tiredness or stress a recognized form of legal damage, or does he need to prove more? For Becky, her damage is the loss of a phone signal. This is the ultimate test for our scenario. Is a blocked signal a loss of amenity that the law is willing to protect, or is it considered a mere delight that doesn't qualify as legal damage? Now that we have all our rules in place, it's time to move into the analysis phase of IRAC. Let's start applying these principles to Andy and Becky, one by one, to see who actually wins. Now we move into the analysis phase. We've established the rules, now we apply them to the facts to see which claims hold legal weight. The first hurdle is standing, and here the law is quite strict. In respect of Andy, following the rule in Hunter v. Canary Wharf, a claimant must have a proprietary interest in the land. Since the scenario explicitly states that Andy owns his home, he is an owner-occupier. This gives him the clear legal standing required to bring a claim against the factory. He has passed the first test. The defendant, on the other side, we have Super Screens. As the occupier of the land and the creator of the alleged nuisance, the noise, lights, and the building extension, they are the correct party to be sued. In respect of Becky, we must address her claim separately, and here the application becomes decisive. Although Becky is suffering from the loss of signal, the law under Hunter clearly states that family members, children, or licensees who do not have a legal interest in the property do not have standing to sue in private nuisance. Because Becky is a 15-year-old daughter living in her father's house, she lacks a proprietary interest. This means that regardless of how frustrating the blocked signal is, her claim fails at this first hurdle. With the parties now settled, we can focus our analysis exclusively on Andy's claim to see if the interference he is suffering is actually unlawful in the eyes of the court. Having cleared the hurdle of standing for Andy, we now move to the second part of our application, indirect and continuous interference. Identifying the source. When we look at the alleged nuisance, it's clear that the noise from the lorries, the bright lights, and the sounds from the production process are all indirect sources. They aren't a direct physical invasion like someone walking onto Andy's land. Rather, they are escaping from the factory and traveling onto his property, which perfectly fits the definition of private nuisance. The continuity test. The law generally requires a nuisance to be more than just a one-off event. In our scenario, the production is now happening night and day. Legal authority. Because this activity is constant and ongoing, it would definitely be considered continuous under the principle in Crown River Cruises v. Kim Bolton. This case reminds us that while even a short-lived event can sometimes be a nuisance, a permanent shift to 24-hour operations makes the interference much harder for a defendant to justify. So, we have an indirect interference and we have clear continuity. But is it unlawful? To find out, we have to look at the factors of reasonableness, like locality and duration, which we will tackle in the next part of our analysis. Moving on to the application of the locality factor in the law of nuisance. Let's look at how this applies in practice, specifically referencing the case of Crown River Cruises. When assessing whether a nuisance is unreasonable, the courts must consider the character of the neighborhood. In this context, two key points arise. First, the move to 24-hour production must have the potential to fundamentally change the nature of the locality, regardless of what that area's current status may be. The court looks at whether the activity shifts the character of the environment in a way that creates an unreasonable interference. Second, regarding duration, even if the interference has only started recently, the court will evaluate whether its duration is long enough to constitute a nuisance. As established in Crown River Cruises, the court will weigh the temporal aspect of the disturbance against the impact on the claimant's use and enjoyment of their land. Remember, in nuisance claims, the locality isn't just about what the area is now. It's about whether the defendant's actions are making that area unreasonable to live or work in. We now turn to the final factor in our reasonableness assessment, social utility. This is where the court looks at the big picture, asking whether the defendant's activity provides a benefit to society that makes the interference more acceptable. In our scenario, we have a classic clash of interests, public need versus private comfort. It can be argued that computer screens are not an essential public necessity. Unlike a hospital or a power station, producing screens doesn't serve a vital life-saving function that justifies keeping a neighbor awake. The employment factor. However, Super Screens has a powerful counter-argument. By moving to 24-hour shifts, they are providing significant local employment. As we saw in Miller v. Jackson, courts are often reluctant to shut down activities that serve the broader community's interests. Applying this to Andy, the court faces a difficult balancing act. Does the economic value of these local jobs give the factory the leeway to operate 24/7? While the social utility is high, the law, specifically under Article 8 of the Human Rights Act, generally protects Andy's right to a private life and sleep. But even if we find the factory's behavior is unreasonable, the battle isn't over. SuperScreen still has a few cards left to play. Does the fact that they have planning permission protect them? Or can they argue they have a statutory authority to expand? Let's move into our next slide to examine the defenses and see if the factory can successfully shield itself from liability. Now we move to one of the most misunderstood areas of private nuisance, planning permission. SuperScreens has expanded their factory, and they likely have council approval to do so. But does a permit from the local council act as a shield against a lawsuit from a neighbor? The general rule. The short answer is no. As established in the landmark case of Coventry v. Lawrence, planning permission is not a get-out-of-jail-free card. The council cannot grant a defendant the legal right to commit a nuisance against their neighbor. The locality nuance. However, there is a catch. While permission doesn't authorize the nuisance, it can change the character of the locality. If the council grants permission for a major industrial expansion, the area might shift from quiet residential to industrial. What was once unreasonable might become reasonable simply because the neighborhood has changed. Applying this to Andy. Andy needs to look closer at the specifics of that permission. Even if the factory has permission to build the extension, did the council authorize 24-hour production? Often planning permission comes with strict conditions about operating hours. If the factory is operating outside those hours, their defense effectively disappears. Furthermore, given that they are making computer screens, a product of relatively low social necessity, it is unlikely that planning permission alone will override Andy's right to sleep. But there is an even stronger version of this defense that we need to consider. What if the factory wasn't just given permission by a council, but was actually authorized by Parliament itself? Let's move to our next slide to look at the defense of statutory authority. We now look at the highest level of legal authorization, statutory authority. This defense applies if SuperScreens can prove that Parliament has authorized their activity through specific legislation. The statutory scheme. As established in Malice v. Thames Water, if a detailed statutory system of regulation exists, a claimant like Andy might be required to seek a remedy through that specific system rather than through a private nuisance claim. Effectively, the law can legalize an interference if it serves a statutory purpose. The timing factor. We must also apply the logic from Halsey v. Esso. In that case, the court famously found that while an industrial activity, like filling petrol tankers, was perfectly reasonable at 10 o'clock in the morning, it became an actionable nuisance at 10 o'clock in the evening. This is a vital point for our scenario, where the factory has shifted to 24-hour operations. Applying this to Andy, for SuperScreens to succeed with this defense, they must prove that the noise and light are an inevitable consequence of their authorized work. If they could have operated the factory more quietly or used shielded lighting to protect Andy's home, the defense of statutory authority will fail. Given that they are a private commercial factory making computer screens, finding a specific act of Parliament that protects their right to create nighttime noise will be a very difficult hurdle for them to clear. But even if the factory feels safe behind their permits and statutes, there is one final modern defense we must consider: the Human Rights Act. Let's see how Article 8 might change the game for Andy's right to sleep. We have navigated traditional defenses, but we must now address the modern constitutional layer, Article 8 of the Human Rights Act. The core argument: Article 8 protects the right to respect for private and family life and the home. While usually used by claimants to sue public authorities, in the world of nuisance, it serves as a vital proportionality check. The case law. As we saw in Malice v. Thames Water, the courts have used the HRA to determine if a statutory scheme, like the one regulating a factory, is actually compatible with an individual's right to live in peace. Applying this to the scenario, SuperScreens may argue that their expansion is a public good, but the HRA forces us to ask, is the interference proportionate? 1. For Andy, if the 24-hour noise and glare are so severe that they prevent him from sleeping or enjoying his home, he can argue that his Article 8 rights are being infringed. 2. The public authority link. If the local council granted planning permission without properly considering the impact on Andy's private life, that decision itself could be challenged as a breach of the HRA. However, the HRA is a double-edged sword. The court must balance Andy's right to sleep against the economic well-being of the country, which includes the jobs and products SuperScreens provides. Often, if the social utility is high enough, the court will find the interference is proportionate, but it might still award Andy money to compensate for that loss of rights. We have now exhausted the defenses. The only thing left is to see what the prize is at the end of the legal battle. Let's move to our final section on remedies. We have reached the end of our legal journey. After analyzing the interferences, the standing of our parties, and the factory's potential defenses, it is time for the final verdict. For Becky, as we established earlier, despite the frustration of losing her phone signal, Becky lacks the proprietary interest required to sue in private nuisance. Because she is a licensee in her father's home, her claim ends here with no legal remedy available. For Andy, the court is likely to find that Supa Screens has committed an actionable nuisance. The 24-hour noise and glare constitute a continuous and unreasonable interference with his enjoyment of his land. While the factory has strong arguments regarding social utility and providing local jobs, these do not grant a license to commit nuisance. The choice of remedy. Following the Supreme Court's guidance in Coventry v. Lawrence, the court must decide between an injunction or damages. 1. Injunction. Andy would likely ask for an injunction to stop the night shifts entirely. However, given the factory's importance as a local employer, a court may be reluctant to shut down operations that benefit the community. 2. Damages. It is more probable that the court will award Andy compensatory damages for the loss of immunity. This allows the factory to continue its 24-hour production while financially compensating Andy for the reduction in his quality of life and the value of his home. Thank you for watching, and good luck.